again, if you're in business and you're doing day-to-day business and you're not a mafioso or something like that, we should not be dealing with the subject of illegality, although there are some twists in it that we're going to touch on in chapter 17. And so there's a whole list of ways that we can create an illegal contract that are short of being criminals in the traditional sense. So one of the things is if it's about gambling, and one of the examples we usually use with regard to this topic is that you go to a Super Bowl party and everybody puts up a few dollars, and you do certain, sometimes you do it by the quarter, and who's ever got the right numbers at the end of each quarter and so forth. And then the big winner is whoever picked the right score and the right team. So in any event, suppose that you go to a Super Bowl party, you participate in the joint adventure, and the host of the party at the end of the evening just takes all the money that's been put up and says, hey, I'm going to put this towards the food for tonight. It's been nice having all of you over for the night. Tough luck. Well, in that case, one of the people who would have won the lottery for the Super Bowl score is very upset. So they go to court and say, you know, I won the kitty. I should have gotten the $200 or $300, whatever it was. Almost certainly the judge will not hear the case. It'll be punted, as the phrase is on this slide, because it's an illegal thing to do. You can only have legal gambling in the United States if it's state sanctioned in a particular facility. If it's not, tough luck. You can't enforce it. So you must have a valid legal purpose. And generally speaking, what happens in those cases is the court will not enforce an illegal contract, and they will rescind the case in some cases, which means they'll simply put people back where they began. I'm sorry, I went back instead of forward. One of the things to be careful about is, especially if you're in international transactions, is the situation here regarding an executive order. So you cannot do business in certain countries around the world. Probably the best known example is the country of Iran. You cannot, as an American citizen or an American company, do business in any way with the country of Iran or any of its interests inside the country of Iran rather. And so any deal that you make that involves being obligated to do something that involves Iran is not enforceable. In fact, if you do certain things or try and sell certain products to Iran, you could go to jail, in fact. So there are certain circumstances where the deal may be protected. The party is within a group to be protected. That could be somebody who's in a mental facility or a minor who's under 18. So even if the contract was illegal, the court will endeavor to put the person back where they started. So say that you have somebody who's in a mental facility, puts up $50 towards a Super Bowl pool. They can't enforce the Super Bowl pool, but since it was an illegal activity that they weren't authorized to be in, they can get their money back. Now, the next part of this chapter 17 moves into a little bit different area, and that is if something is a violation of a statute. So the gambling cases pretty much fall under this. In most states, gambling is illegal. And so it's simply void and unenforceable if it violates the statute. but we're going to move past that. One of the things that's a good, for instance, here in Texas is I mentioned I'm in the process of selling a property, and I've got an option contract built into the deal and so forth. But if there's a situation that comes along that, for instance, there's a real estate agent, a friend of mine, who is handling a transaction. The state law in Texas says that that real estate agent can only collect a commission under certain circumstances. One, the agent must be a licensed agent here in Texas. Two, the commission must be paid to the agent's broker if the agent, him or herself, is not a broker. And three, very importantly, they cannot collect any commission if they do not have a written commission agreement in place with the seller. So it's important to keep that in mind.
I can't go down the freaking stair.
Go ahead. Are you asking a question?
You don't want to go in the back.
Okay. Folks, please be careful to mute your mic if you're not asking a question. That's disruptive to the other people participating in the call tonight. Thank you. Now, one of the things that happens from time to time is that people practice whatever they're doing, selling real estate, practicing medicine, doing other things that require a license that's designed to protect the public. We had a very visible public case of this here in Houston a few years ago. Situation is out on the western part of Bissonnette is a large Hispanic area. There was a gentleman out there who ran a dental clinic and had hundreds of patients. I believe 200 or 300 patients were going to this alleged dentist. And he went along for a while pretty well and had a lot of people patronizing him. But what happened is that he fouled up somebody's mouth. The lady was in a lot of pain. She went to a different dentist. The dentist looked in the lady's mouth and said, "You did not get this done here in Houston. This is how it's done in Mexico." And the lady said, "I have not been to Mexico. I got this done at XYZ down on Bissonnette." And so the dentist who analyzed the problem contacted the dental licensing board, and they went out and criminally charged the dentist with like 300 counts of criminal mischief or whatever for operating a dental practice without being licensed to practice dentistry in Texas. Now, the significance of this for contracts is if he was doing braces, which are usually paid over time, or if he had patients who had had an expensive procedure done and they hadn't finished paying for it, as soon as the state intervened and said this person's operating a legal dental clinic, the person could no longer collect anything that was still open for that person to do. Again, that's the way that works. They cannot collect anything even if the person signed a contract, the contract would be illegal, not just voidable, but illegal. We don't hear the term usury very often. Usury was a very, very big deal here in Texas. Texas was started as a debtor colony, and it was a state that deliberately limited the interest that could be charged to most people to protect the public in general. And it caused a lot of problems in the 1980s and late 1970s, early 1980s, when the United States had runaway inflation for a while. And what would happen is the interest rates, if you wanted to borrow some money to buy a house, get a mortgage, if you needed a credit card and all that, you couldn't do it because the interest rate was so limited by state law. So the state of Texas reluctantly relaxed its usury law. The usury law is still out there, but it is not doesn't really affect very much. Obviously, many of you are familiar with these, what they're called payday loan lenders, who lend money for short periods of time at very high rates of interest. Under normal circumstances, that would have been considered usury. But again, because of the crisis that hit in the late 70s and early 80s in the United States, the state of Texas heavily modified its usury laws so that most interest rates are legal. But the concept still stands. If there is a legal interest rate over which a business cannot charge, then that is a usurious rate. It exceeds the standard. But again, this is something that is difficult to enforce today because of the wanting to keep commerce rolling. This is an interesting place to have this information inserted in our course, but normally I would have looked at antitrust laws in a separate chapter by themselves or in the administrative chapters near the end of the course. But in any event, they put the antitrust laws in here. I actually have a article pending regarding antitrust that I've not submitted for publication yet, but I'm about to do some final cleanup work on it, submit it for publication. But basically, the antitrust laws grew out of the tremendous expansion of the United States economy following the Civil War. So basically in the Civil War, the North, which prevailed in the conflict, expanded its manufacturing capacity and was very successful. The South, which was much more agrarian, was unsuccessful, even though they were defending their territory rather than attacking per se. What happened is that there's a lot of industrial expansion in a fairly short period of time. And so there was a particularly egregious case, and that's one you've probably heard the term, John D. Rockefeller. He started the oil industry in Texas, and he was actually started in Ohio, but he owned substantial interest here in Texas. But John D. Rockefeller deliberately set out to be a monopolist. His idea was to totally control the growing oil industry in the United States. And why was that a growing industry? Because they were starting to invent locomotives and starting to invent sailing ships that operated with motors instead of sails, and they're starting to invent the automobile. The automobile, of course, was what really drove the distribution of petroleum products. Also, people wanted to light their houses before there was electricity. There were oil lamps in people's houses, and so on and so forth. So in any event, the industrial expansion following the Civil War produced a tremendous concentration of businesses in a very short period of time. And most of us became aware of this in our high school history classes, and these people were colorfully known as the robber barons. Many of the names of the robber barons are still famous today, and a couple of them are J.P. Morgan Chase. J.P. Morgan was a famous monopolist financier. Andrew Carnegie ran the steel mills in Pittsburgh. Of course, his name is in Carnegie Mellon University in Pittsburgh today. And you've got Vanderbilt, who also has a university named after him. He was in shipping. And you have Jay Gould, and Jay Gould was in transportation. His railroad car is actually on display here in Texas because he, prior to cars, he traveled by railroad. And so there's actually a Jay Gould fancy railroad car on display. And so some real interesting things with these very famous people, but the most famous of them all was Rockefeller. And of course, we had the Rockefeller Center in New York City. And that is indeed named after the people that acquired the money after John D. Rockefeller passed away. But in any event, as early as 1890, only 15 years, 25 years after the end of the Civil War, the Congress of the United States realized that allowing just a few people, these robber barons, to control so much of the economy and huge pieces of different industries was dangerous to our capitalist system. And so the Sherman Antitrust Act, again, was passed in 1890. It provides for federal prosecution and also provides for private prosecution. And it was designed to really knock things down. Unfortunately, it was not as effective as might have been because people, went to great lengths to avoid looking like they were monopolizing. And so one of the things they did is to create interlocking directorships where they had different companies that were owned by different people, but the way it was structured is that they were all in bed together so that the companies did not really compete with one another. And so what happened is we later needed to pass the Clayton Antitrust Act around 1911 in order to prohibit the agreements that were designed to frustrate the purpose of the Sherman Act. Now, my paper that I mentioned a minute ago that I have not released yet is specifically on the rule of reason, and that the rule of reason has been used largely in the modern era to allow these huge mergers that we've seen that have taken place. And again, relating directly here in Houston is the merger of Exxon and Mobil, which took place in the later 1990s and which was absolutely a combination and restraint of trade, and yet the federal government signed off on it. Specifically, price fixing is illegal. A good example of this is, as you know, right near the university campus, we've got two gas stations across the street from each other. On the other end of Montrose at Richmond, we've got a couple gas stations near there. And so if these folks call each other up and say, hey, let's make a lot of money this week, instead of charging $1.59 for a gallon of gas, let's charge $1.79, and they both agree that is illegal price fixing. It's violation of federal law. You can also divide territory. We see this most often in the case of real estate, where different real estate brokers will get together and somebody's making a market in River Oaks, another person's making a market in Memorial, and they agree not to go into the other one's territory or to try and get listings in the other area. That is an illegal restraint of trade, and that is per se illegal. The book also mentions the Robinson-Patman Act in number 2. And that's a price discrimination there. And that is that you see people coming, you see your buddy coming, and you say, well, I'll ship your corn up to Kansas for 10 cents a ton. And then another person comes in and they say, oh, well, we'll ship the same corn the same direction, we'll ship your corn for 20 cents a ton. It's illegal to charge different amounts to different people. The assumption underlying that is that you are doing it in order to restrain trade. Now, there are a lot of exceptions in price discrimination, and I'll use a very simple example that's a real-world example. There was the last family department store inside the city of Houston, inside the Loop, the 610 Loop, was a store called Kaplan's Ben Hur. It had a colorful name. It was up in the Heights. It was on near 20th Street. And so what happened was that the store, like many department stores, had been in decline, and they were struggling along by the late 1992, 98, 99. And the operator of the business at that time was the grandson of the founder. He had his MBA from the University of Texas, very bright guy, very nice guy. So anyway, he told me, personally told me this story. He said that there were very little overlap between the products that were sold by Kaplan's Ben Hur and Walmart. But sure enough, Martin, the guy who was running Kaplan's Ben-Hur in 1999, said that he went into a Walmart store and saw a same item that they sold for less than his wholesale price. Now, you might say, well, Dr. Schein, hey, this price discrimination is illegal. How can Walmart be paying so much less than Kaplan's Ben-Hur for the same item? The answer is that you can discriminate on price if there's a financial reason for doing it. And I think most of you know, or you have enough knowledge of business to know that Walmart buys stuff in massive quantities and ships it in its own trucks. In some cases, they buy it overseas and actually buy it so they own it before it leaves the ports in China and Vietnam and so forth. And so that by the time the stuff gets here, it's already been pre-priced and all that. So Walmart has a huge price advantage over a small business that might sell a fraction of that volume and is obviously dependent on jobbers or middlemen, as they're called, to get the product. So that's not price discrimination if it's based on a legitimate cost differential. A tying agreement is a very specific type of a deal. And the famous case in this area involves how we originally communicated with computers before personal computers were developed. So when IBM, International Business Machine, IBM first invented, the popular computers that became standard at all different businesses, there were no mouse communications. There was no way to sit at a keyboard or to use a mouse to directly communicate with these big computers. Many of you are aware of the ones and zeros. Well, how do you tell a computer to do things? Well, the way you did it back then was to put a set of cards through the computer. So it was a two-step process. You would sit at a terminal that had a machine that would make niches in the cards or make holes in the card. And you would sit there and type in your commands, and the machine would make holes in the cards that look like a modern time card. So you'd have a whole stack of cards in order to give a command to these big mainframe computers. You would then go to a feeder on a corner of the computer and feed the cards in order, and that would give the computer instructions to exercise a particular thing. In any event, most of these huge computers were leased, not sold. And IBM said, if you're leasing our computers, you might screw them up if you use cheap punch cards. So you can only buy punch cards from us, IBM. And of course, they were selling them at quite a handsome markup. Well, the courts found that that was illegal. It was an attempt to monopolize. It was illegal per se. It was illegal on its face. Now, parallel to the antitrust agreements and some of the things we talked about are interests to the public and things that violate public policy or public welfare. So these could be things that says that, we want to go ahead and pollute. So we're going to agree that we're going to keep polluting, and we're not going to tell anybody because it's just you and us sharing this little creek. So as long as we both dump bad stuff in the creek, nobody's the wiser, and we're going to get away with it, save a bunch of disposal money. So that type of agreement to deliberately violate the environmental protection laws, either local or federal, is the type of thing that we're talking about there. And there's all sorts of agreements that you can come up with. Right now, you might say you've got businesses that are not honoring the social distancing rules and things like that. And if you do have those situations, then it's important to realize that there will be a need for you to follow the situation and to follow the law. If you make deals with other businesses and say, well, hey, we've each got a bar. If one of us follows the social distancing and the other doesn't, it's going to hurt the one that follows social distancing. So the two bars agree that they'll both allow people to be as close as they want to be in the bar, and that would be a violation in contravening public purpose. It's things like that. And one of the things that I get asked a lot by our students, and especially if they're heading into the workforce, is if I sign an agreement not to compete, can that prevent me from getting another job in the future? And the answer to that is that agreements not to compete are indeed enforceable. It's just that they are very, very limited here in Texas. And they have to be limited in terms of geography. They have to be limited in time. And importantly, they have to be limited in scope. So if you're a salesperson for a company, and even if it meets the limitation in time, but it doesn't limit your, it doesn't stipulate the type of business you can do, and they come in after you leave that company and you go to the new company, and the first company comes in and sues and says, well, you're in there doing mechanical work and you're violating your non-compete. Not going to do very well, because if you were doing sales for the first company, they may be able to interfere with your sales, providing that you're doing other things that are required under the contract. But in other words, the contract is valid for scope of work and length of time, but it's not valid on one other issue. So these are some very important things to keep in mind in the state of Texas. Now, it's going to vary from state to state. And so to give you an example of this, in California, non-compete agreements by state law are not valid. In contrast, state of Virginia, I practice in both Texas and Virginia. In the state of Virginia, contracts are, non-compete contracts are easily enforceable. And so Texas, again, kind of sits in the middle, where if the contract is reasonable in the way it's structured, then it may be okay. But one of the problems that you run into in Texas is that judges are politically elected, and judges do not want to keep you from working. So a lot of times they go to great lengths to avoid the agreement not to compete, in order not to look like a bad person and maybe get defeated at the next time they run for re-election. So it's kind of an interesting area of the law. But again, it must be reasonable, and it must be very specific in terms of the way the agreement will be applied. And they do include in the book an example of Emerson Electric. Of course, Emerson Electric is a big manufacturer of consumer products and other products. And that's an example of the agreement being enforced. One thing to keep in mind is the higher that you are in the organization, the more likely a court is to enforce the non-compete agreement. Also, unfortunately, geography is one of the three areas of debate. Again, we have geographic restriction, we have the type of work being done, and we have the length of time. In Texas, generally up to 2 years is generally considered an enforceable period. If you work in the greater Houston area, the geographic restriction may include Harris County and every contiguous county to Harris County. That's a pretty good chunk of real estate, but it might still allow someone to go to work, say drive up to Austin or someplace like that. But a number of senior executives sometimes are involved in national sales, where the company wants to prevent them from doing anything in the United States. And those can be very punitive contracts. So something to keep in mind there. So we had talked about unconscionability earlier when we talked about the Texas Deceptive Trade Practices Act. And a part of it is that keep in mind that unconscionability is kind of in the eye of the beholder and the eye of the judge. As business people, it is harder to argue unconscionability than it is as a individual. So as an individual consumer, if you are in a situation where you say, I got into a bad deal, the courts are more likely to bail you out. If you're a business person, the courts are going to be like, well, you're a sophisticated business person. You're supposed to be able to, represent yourself and do things responsibly. Also, you've got the responsibility, if you don't understand what you're agreeing to bring in an attorney, and that's what a good business person does. So be careful about this overall concept. It is available to business. It is available under the Texas Deceptive Trade Practices Act to small and medium-sized businesses, but it's not a get-out-of-jail-free card. So procedural unconscionability deals with how the deal works. Substantive unconscionability is the deal itself is a bad deal. Now, again, we talked about contracts of adhesion, and again, the best known example is from the movie, the original Godfather, and make him an offer he can't refuse. But there are other circumstances. Perhaps in our modern era right now is price gouging is illegal during COVID. It's illegal by law in the state of Texas. So if we have a flood or we have a hurricane and somebody has a 78-cent bottle of water and they charge $10 for it, that is a contract of adhesion. Somebody is, they've lost their water supply. They need water for their family so they don't die. And the person's charging an unusually large amount of money. So that's also another circumstance where you might find a contract of adhesion. One of the things that lawyers are often involved in reviewing in contracts, because again, you business people are going to be cutting the deal and coming up with the different bases for how the contract should work and things like that. But in a lot of cases, especially here in Texas, I work with small companies that provide services to these huge oil companies like Shell Oil and Chevron and ExxonMobil and so forth. So a lot of these contracts say, hey, if you, Joe's Plumbing Service, come out and work in our plant and fix some pipes, if anything at all happens that's bad while you're here, even if we do it, we being the oil company, it's your fault. And so this can make it very punitive for a small business to do business or provide services or products to large companies, because they're like, hey, I can't absorb this level of loss. So oftentimes the answer is that to go to your not your mortgage company, but your insurance company, and to say, hey, I'm thinking of signing this contract to provide services at this refinery, but I can't absorb this level of responsibility if something goes bad while I'm out or my crew is out at this refinery. So usually the first step is to try and negotiate a more reasonable exculpatory clause. And sometimes I'm able to do that on behalf of some of my clients. In other cases, then the client will go to their insurance company and say, can you give us insurance so that this particular liability, if it happens, will not bankrupt our business? So this is the way you need to think about it. And again, we talked about insurance when we talked about the torts chapters on our first night of class. So we want you to, again, think about the fact that you need to be proactive in protecting your business. We touched on this briefly when we talked about bailment. So again, this is the example where you drive into a parking lot, you pull a ticket so they know how long you were there to charge you for parking. And the ticket says, this is not a bailment. This is just a license. You can park anywhere you want, not our problem. Those will probably be enforced. Somebody drops a rock on your car, unless it's the people running the parking lot, you're probably going to have to use your auto insurance. You won't be able to recover anything. Slightly different scenario, but a very important difference. You go to a restaurant on Friday night and you valet park your car. Now, as I mentioned when we talked about bailments, you very well will get a ticket that looks a lot like your parking receipt that says, we have no responsibility, it's not a bailment, all this jazz. See, the problem there is that you have been required to surrender your car to the organization. And since they have possession of your car, not so easy for them to avoid responsibility. So be aware of that distinction depending on how the things are handled. And that's why they mention in bullet number 2 here on this slide 23, many terms on tickets may be unconscionable and will not be enforced. If you've had to turn over the car keys and the people really do have control of your car, then they should be responsible for it. As I mentioned when we hit this the first time the other night, it's difficult to proceed if you do have damage. I've actually seen people at a valet park with an expensive car who in front of the valet parker stood in front of them and took some pictures of the front and back of their car to kind of remind the person driving the car, the valet parker, that they're going to be taking a look at the car when it comes back and it better be in good shape.